Polyandro.
All right, good morning, and this is the time and date set for a probation violation hearing. Do you know how we're proceeding, Mr. Vogler?
Yes, I do. So Carol will be admitting to all three counts.
Ms. Polyandro, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. You understand you have the right to have a hearing, and where the allegations would need to be proved by a preponderance of the evidence, the right to the assistance of your attorney and to present evidence in your own defense, question the evidence presented against you. Do you understand those rights?
Yes, I do.
Okay, Ms. Polyandro, we've had prior violations with you, so that therefore these would certainly be sufficient violations that I could revoke your probation. So you're on probation for possession of controlled substance. Looks like that's a maximum penalty of 2 years. Do you understand the maximum penalty that you could face?
Yes, sir, I do.
Okay. Has anybody promised you anything in exchange for your plea?
No, sir.
Has anybody threatened you?
No, sir.
Is it your own free choice to enter that plea?
Yes, it is.
Right. Knowing all this, how do you wish to plead to the allegation that you violated probation? Guilty or not guilty?
Guilty, sir.
So, Ms. Polyandro, are you on probation to me for possession of a controlled substance?
Yes, sir.
As part of that probation, were you ordered to call the drug testing line as directed?
Yes, I was.
And were you also ordered to submit to drug and alcohol testing as directed by your supervising agent?
Yes, I was.
So on June 17th, did you fail to submit a test after being directed to do so?
Yes, sir.
And on June 19th, did you fail to call the test line as you were directed to do?
Yes, sir.
And on June 20th, did you also fail to call the drug line?
Yes, sir.
Mr. Vogler, you're satisfied with the factual basis?
Yes. Yes.
Mr. McLennan?
Yes, Your Honor.
Mr. Vogler, are you aware of any promises, threats, or inducements?
None.
Mr. McLennan?
No, Your Honor.
All right, Ms. Polyandro, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and in law to believe that you violated probation in all three respects. So I'll accept your plea. At this point, we probably should have a probation violation report prepared and schedule this for a sentencing hearing. I could put it on in roughly 3 weeks. Agent Walesky, is that sufficient time to prepare the probation violation report?
I'll make it work.
Okay. All right, I wouldn't do that on a full PSIR, but on a PVR, I think I want to smooth it along. So we'll schedule it for sentencing on August 11th at 9:50 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay, Ms. Polyandro, we'll see you for your sentencing August 11th at 9:50 a.m.
Thank you.
All right, and that brings us to sentencing in People v. Thomas Kurtz. It's file 24-93305FH. So you want to state your appearances, please?
Jeremiah Buffalo, we're on behalf of people.
Jesse Williams, present with Mr. Kurtz, sitting to my left.
Okay, good morning. And Mr. Williams, have you had a chance to review the pre-sentence report and recommendations with your clients?
I have, Your Honor.
Do you have any additions or corrections to the information in that report?
I do. We go to page 1 of, we go to evaluation of plan and then go down to additional information.
Okay,
And that last paragraph, it indicates, where did it see? Oh, the underlying offense of accosting, which we judged that at the time of the plea. We didn't do that because we would have invoked the catch-all on the SORA. And the factual basis we used was not that of a costing. So I just don't want that to cause any future.
Well, can I see this one? I mean, the plea agreement I'm looking at does have that phrase with underlying offense of accosting with penalties pursuant to 752.793D and MCL 750.92.
I know it did, and then I just got the transcript. I guess I'm not concerned as long as SORA is not going to be an issue.
Yeah, I'm not going to order SORA.
Then I'm not going to.
And I don't even know if accosting it. I don't know. Yeah, I'm not going to order SORA.
Okay, then there's no issue there. Then if we go down to recommendation, description, narrative. Let me see here. Okay, when we go where it says consecutive sentences, we go to the paragraph right above that. Mr. Kurtz did not admit that he drove to engage in sex with a 15-year-old. He denies that. If that's the narrative of the incident report, we'll just challenge and say that he denies that statement. But that's.
I mean, what do you want me to do with that? I mean, he drove
Just, can
from
we just
Traverse City.
add a sentence that says, just add a statement that says he denies that? He just denies it.
He denies that he admitted to it.
Correct. He had never engaged, never intended to have sex with any 15-year-old. In fact, he said, I'll pay you extra to prove that you're 18. So he denies that he admitted that he drove there to have sex with you.
That's an important fact for me. I mean, I think we maybe ought to have some. Do we need to have a sentencing evidentiary hearing on that? I mean,
I would say so. This is a silly situation where we have a TV program essentially working in concert with law enforcement and a lot of stuff going on. I would not shy away from that evidentiary hearing on that issue, particularly after we got the playbook from these folks. I'm not asking for that evidentiary hearing. I'm just simply asking that the court acknowledge that Mr. Kurtz denies that he had any intention of having sex with a 15-year-old.
I can't possibly sentence him without deciding that issue. So the rules of evidence don't apply at a sentencing hearing, but I do need to have some information presented by the prosecution that would show by a preponderance of the evidence that he admitted that he drove to the motel room to engage in sex with the 15-year-old female. Mr. Virgo, I know that you didn't have sort of notice of that. Are you prepared to present any evidence in that regard today, or?
Your Honor, it's a possibility if I can reach a detective that I do know is on duty right now, but I don't think I
can. Is this the detective that was involved in the case then?
Yes, we had a local detective that was present for the interviews as well, and he may be able to corroborate that. I'm not positive, Your Honor. Again, I wasn't anticipating this issue, but it is an answer I could potentially have for you within 5 minutes.
Well, we got a couple different options. One, we can try to cobble together something today to get on the record whether there's sufficient evidence that he made that admission to police. He may not, today continue to endorse that admission, but it's important to me whether he made that admission or did not. We can either take some testimony today, either in person or by video, or we could grant a continuance so that we can have a sort of a mini evidentiary hearing. Mr. Williams, what are your thoughts?
Your Honor, I would prefer if we can just get it done today to do that, but there's a recording that should be real. I'm assuming that statement came out of interviewed recording, so perhaps they could re-review their recording and decide if that's an appropriate statement or not. I think that would cut to the chase quickly. He was interviewed. I mean, everything that occurred, they captured on film as part of this TV show. So. And I'm pretty sure this was the one where the editor or something was present in the room when my client was being interviewed related to this statement. So the director, whatever.
Okay, we'll see if you can determine the officer's availability. I have one more matter to take. We'll pass this case least find out what the officer's feeling.
Thank you.
Do I have Mr. Twos available? Mr. Twos present?
All right, let's talk about that. The hearings for People v. Carol Polyandro and People v. Thomas Kurtz once again brought us into familiar territory, substance-related probation violations on one hand and a much heavier, fact-sensitive sentencing on the other. But in both cases, Judge Aaron J. Gauthier proved why consistency and clarity on the bench matter so much. Starting with Ms. Polyandro, the hearing was brief and without complications. Represented by Mr. Vogler, she pled guilty to all 3 probation violations, failing to submit to drug testing on June 17th and failing to call in on June 19th and 20th. Judge Gauthier walked her through her rights, confirmed the plea was voluntary, and found a sufficient factual basis to accept it. The judge noted her prior violations and made clear that revocation of probation was now well within reach. Still, he moved forward with a probation violation report rather than a full pre-sentence investigation, aiming for efficiency. Sentencing was set for August 11th at 9 a.m. The entire exchange reflected a familiar but fair rhythm, for the court acknowledged the pattern, keep things moving, and leave space for accountability without immediate punishment. Then came Thomas Kurtz's sentencing, and that's where things got far more complex. Mr. Kurtz, alongside attorney Jesse Williams, challenged key language in the pre-sentence report, especially the claim that he had driven with the intent to have sex with a 15-year-old. The charge itself had been carefully pleaded in such a way to avoid triggering Michigan Sex Offender Registration Act, SORA, but the PSI narrative still included those allegations. Williams insisted on the record that Kurtz denied both the intent and the admission, and the judge agreed that this issue couldn't just be brushed aside. If the court was going to consider those allegations at sentencing, it needed evidence. Judge Gauthier, as always, was meticulous in explaining the legal ground. While evidentiary rules are looser at sentencing, he couldn't simply accept contested claims without some substantiation. Prosecutor Virgo said he might be able to reach the detective involved within a few minutes, and noted that the entire incident was part of a TV show sting, potentially with video evidence. Defense counsel didn't object to a short delay, but emphasized that if the statement came from a recording, that recording needed to be reviewed to verify what was actually said. Gauthier gave both sides the option: either try to produce the evidence immediately or pause and reconvene with more clarity. The court chose to pass the case temporarily to see if a detective could be brought in on short notice. What stood out in both matters was how Judge Gauthier anchored each proceeding in careful, principle-based reasoning. He didn't rush to revoke Carol Polyandro's probation, nor did he jump to sentence Thomas Kurtz without making sure the record was clear. One hearing involved a cooperative admission and treatment compliance. The other raised major implications of guilt by implication hinging on a disputed narrative, a possibly televised sting, and an unclear evidentiary trail. And through it all, Judge Gauthier remained measured, transparent, and focused on the law, not the noise. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.